This is Module 3 of March 15th to 19th for American Political Thought on slavery in the founding. And I'm going to conclude with Wilentz's book and then turn to Storing's article to kind of, which again, by and large, dovetails with Wilentz's thesis. And in Storing's somewhat detailed analysis, and one should say refutation of Chief Justice Taney in Dred Scott, he nevertheless does open up a deeper question, one might even say a radical question, on the question of the consistency of slavery, and that has to do with the nature of natural rights itself. More about that in a minute. So, in the second part of Wilentz's book, which then traces the radicalization of the anti- and pro-slavery positions in the constitutional regime up through and including the Civil War, what's the story he tells? Well, in some ways, if you go back to my layer-by-layer regime analysis that I gave in the first and the second modules of this course, of this lecture, in some ways both positions hardened and radicalized, and as slavery became more economically viable and changed the place of slavery in the extended regime, the regime of citizen way of life and culture and even economics for that matter, then in some ways you began to see a kind of a hardening on the position, for instance, in the positions of John C. Calhoun, who actually came to repudiate the teaching of the Declaration and argued for real human inequality, and that slavery was in fact a beneficial relationship for both master and slave, and embraced a kind of a confederalism as the remaking of the Union. Again, I think what Wilentz would suggest is the hardening of the position of slavery with respect to the humanity of African Americans, although there was this mixed record in Southern courts, as Storing points out, that the hardening of the pro-slavery positions, which ultimately did culminate in Dred Scott, which is to say, completely overturned the framers, the nature of the Constitution by actually departing from the text, as Storing argues and Wilentz argues, but certainly the intention of the framers not to validate slavery, that's Taney's opinion, following Storing's very close analysis of it, does in fact invert the intention of the framers and sees in the founding what Nicole Hannah Jones sees, as I've already argued in the 1619 Project, which many contemporary observers see, and oddly enough end up agreeing with Taney. So as the pro-slavery position hardened, the confederal claims, the attempt to recast the Constitution back in terms of confederation, as sort of to resurrect the Articles, so as to solve the problem of the Constitution's anti-slavery tendencies, if you follow Wilentz's thesis. Again, his very, just to state again, his core thesis is that the Constitution, while it embraces slavery and protects it, denies any legitimacy and does not create a nationally recognized and protected species of property, which is just the opposite of what Taney holds in Dred Scott. So again, we'll see one of the things that Wilentz's account does, and actually for me really clarified some ambiguities in Stephen Douglas's thought. I must admit I learned quite a bit from Wilentz's book, and it made me see some inconsistencies in Douglas's thought, which explains why his position of popular sovereignty was, although embraced in some ways by Northern Democrats, was rejected by Southern Democrats, and that Douglas actually was eventually marginalized in American life, and of course was the distant third, I think, in the four-candidate president race in 1860. Let's talk about that, as a matter of fact. So remember that supporting the Kansas and Nebraska Act in 1854 which in effect undid the Missouri Compromise of 1820, and in some ways led to there were several things that led to the radicalization of these issues and the formation of the Republican Party as an anti-slavery party, with Lincoln as its primary spokesperson, and of course Frederick Douglass as the primary black statesman of the 19th century, who also came around to Lincoln's position, and one should say Wilentz's and Storing's position too, as I pointed out in the last module. Douglass embraced the idea as an attempt to solve the tensions within the American regime of the position of what he came to call popular sovereignty, and what he meant by that was Congress could not and should not prohibit slavery in the territories as it had done in the Missouri Compromise and as the Northwest Ordinance of 1787 had done, even under the Articles, but rather should allow the people of each territory the majority decision to embrace or to enter the Union as a slave or non-slave state. And that was his doctrine of popular sovereignty. And Douglass was an ardent defender of Dred Scott in 1857 during the Lincoln-Douglas debates of 1858 and in the presidential campaign of 1860. What Wilentz's account, though, shows is that ultimately the pro-slavery position of Taney and Dred Scott, which, according to Wilentz, did, in fact, completely overturn the anti-slavery character of the American Constitution, and in fact, did, in fact, change the regime, which, by the way, shows how powerful a Supreme Court decision can be. Wilentz argues is that, and Storing, too, by the way, following, departing from the express language of the Constitution, Taney holds that the Constitution expressly recognizes a right of property in man, that the Constitution, especially in the Fugitive Slave Clause, recognizes that slavery is a species of property, and one of the grounds by which he overturned the Missouri Compromise and declared it unconstitutional, and that Congress couldn't restrict slavery in the new territories, is that the Fifth Amendment, which says you can't and the Fifth Amendment, which applies to the national government, that nor shall any person be deprived of life, liberty, or property without due process of law. And Taney argued that since the Constitution recognized the validity of slavery as a species of property, hence that meant that it was a deprivation of the slave owner's property when, if in moving to a territory, it rendered that species of property illegal, which, of course, the Missouri Compromise did. Now, of course, slavery was also illegal in the northern states that had eliminated slavery. So Wilentz is probably right, as Storing is right, that ultimately Taney's misreading of the Constitution on the question of slavery and seeing the constitutional compromise with slavery as a validation and an embrace of slavery, and seeing it simply as a pro-slavery document, probably would have eventually spread slavery even to the emancipated states. Because if you argue that Congress, now you could say, well, wait a minute, states could regulate property as they want. But nevertheless, and it's true that there are certain species of property which are illegal in one. I mean, after all, you can buy dope in my parents' home state of Illinois, but in other words, marijuana is a legal property in Illinois, but it's not a legal property in North Carolina. Shocks. Just kidding. Or South Carolina at this point. But nevertheless, it's not clear that would have eventuated, that ultimately Taney's interpretation would have invalidated state laws emancipating slaves. But it certainly invalidated, it deprived Congress of any constitutional power to legislate against slavery. That is a correct reading of Dred Scott. And by the way, both Wilentz and Storing and Lincoln and Douglass, that is to say Frederick Douglass, not Stephen Douglass, all argued that was a misunderstanding or a misconstrual of the Constitution. And that's what led to the resurrected confederalism of of the southern states, which of course led to secession and the Civil War, and the military crushing of the sovereign governments, and the elimination of independent state power over this issue, and the correction, ultimately, the specific correction of what might say that ambiguity in the original Constitution by virtue of the addition of the 13th and 14th Amendments, as we discussed in the last module. So what I want to do is just sort of, in the rest of this module, is set up Storing's argument, his criticism of both the contemporary opinion that sees the Constitution and the U.S. regime as systemically racist, because, in other words, Storing's, and you'll see, well, here, let's just begin with Storing's article, the first page, on page 131. And again, the target of his criticism is the great historian John Hope Franklin, but you can read in this the 1619 Project, as I suggested above. And again, this essay was originally written in 1986, but I think it is accurate to say that if Storing were alive today, he would see it as an adequate response to the 1619 Project, and also, to some degree, to the larger charge of systemic racism. So just following, it is a common opinion today, however, that as admirable as the American founders may have been in other respects, in their response to the institution of Negro slavery, their example is one to be lived down rather than lived up to. A good expression of this opinion has recently come from the distinguished American historian John Hope Franklin. Of course, because this was the impending bicentennial of the Constitutional Convention in 1987. We need to face the fact, Franklin contends, that the founders, quote, betrayed the ideals to which they gave lip service. They failed to take an unequivocal stand against slavery. They regarded human bondage and human dignity as less important than their own political and economic independence. They spoke eloquently at one moment for the brotherhood of man, and the next moment denied it to their black brothers. They degraded the human spirit by equating 5 black men with 3 white men. The moral legacy of the founders is shameful and harmful. Quote, having created a tragically flawed revolutionary doctrine and a constitution that did not bestow the blessings of liberty on its posterity, the Founding Fathers set the stage for every succeeding generation of Americans to apologize, compromise, and temporize on those principles of liberty that were supposed to be the very foundations of our system of government and way of life. Storing continues. This view of the American founding, that the framers excluded the Negroes from the rights of man expressed in the Declaration of Independence and sanctioned slavery and Negro inferiority in the Constitution, a view that the radical abolitionists like William Lord Garrison, as we pointed out, from whom John Hope Franklin descends, shares with their pro-slavery antagonists. And again, the whole point of his essay and his rather detailed account of and refutation of Taney's opinion in Dred Scott is to show that, ironically, this opinion of systemic racism or hypocrisy in the founding, as Nicole Johnson puts it, ironically is in complete agreement with Taney's take. So if you turn to 134, this is Storing's fullest presentation of his thesis. This whole argument, and I repeat, it is identical to the common view today, and this is after he's begun to develop Storing's view. And of course, Storing's account of the facts and the issues in Dred Scott is very good, as is Wilentz's, so you should pay attention to that. This whole argument, Taney's argument that is, and I repeat, it is identical to the common view today, and it is identical to the common view today, since, as I already suggested, is a gross calumny on the founders. The truth is almost the exact opposite of Taney's account, which again is also the thrust of Wilentz's book. The founders understood quite clearly that Negroes, like men everywhere, were created equal and were endowed with unalienable rights. They did not say that all men were actually secured in the exercise of their rights, or that they had the power to provide such security. But there was no doubt about the rights. Far from it being that, quote, Negroes were never thought of except as property, which is what Tawney claims in Dred Scott. Not only Negroes, but slaves were very frequently spoken of and treated as persons. All of the constitutional persons relating to slaves, for example, refer to them as persons. And then he goes on to discuss some of the complexities and nuances, even in Southern courts, on the question of the moral personhood of African American slaves. But again, contrast Storing's interpretation with Hannah Jones's interpretation, that they did not include blacks in the Declaration, and that the Constitution hypocritically embraced slavery as part of the American regime. And further on 142, where he goes on, this is now Storing's account of actually what happened at the founding. And you'll see this is essentially a restatement of, even though it was written 40 years in advance of Wilentz's book, this is essentially Wilentz's position. In their accommodation to slavery, now again, whether or not you're persuaded by this argument depends on how you weigh terms like accommodation or compromise with, as opposed to validation and embrace of. You might argue, well, this is just it's a language game, and there's no difference between accommodating or compromising with slavery and quote-unquote validating or embracing it. Again, you can make up your own mind on that question, but at least you need to see the issues. In their accommodation to slavery, page 142, the founders limited and confined it and carefully withheld any indication of moral approval. Again, in response to John Hope Franklin and Nicole Hannah Jones, not because they knew what they were doing, trying to cover it up and hide it so as to perpetuate slavery, but rather, again, following this interpretation, they withheld any indication of moral approval. While they built a union that they thought was the greatest instrument of human liberty ever made, that they thought would lead, and that did in fact lead to the extension of Negro slavery. It is common today to make harsh reference to the irony of ringing declarations of human rights coming from the pens of men who owned slaves. But I think that Professor Franklin is wrong when he says, quote, they simply would not or could not see how ridiculous their position was, unquote. Storing, they saw it all right, and they saw better than their critics how difficult it was to extricate themselves from that position in a reasonably equitable way. But they saw, into a deeper irony, these masters knew that they were writing the texts in which their slaves would learn their rights. So again, that's essentially Wilentz's thesis, and that which makes the argument following Lincoln, following Frederick Douglass, and etc., and James Madison, that the intention, that the disposition of the Constitution as a regime, as the foundational institutional layer of the regime, was to accept the existence of slavery, but without validating its concept or giving it moral or just status, and reducing, as both Wilentz and Storing say, reducing it simply to a matter of state positive law. And Storing then makes this argument, trying to refute Tawney on each of his specific claims of the three constitutional provisions. And so let's now turn to his rather deep and radicalization or restatement of this issue, which takes this question to a far deeper place, and as you'll see, doesn't criticize the framers for adopting or accommodating a practice that is inconsistent with the principle of natural rights, but strangely enough may reveal a consistency with the principle of natural rights, and therefore reveal a profound insufficiency not in terms of the framers' accommodation to slavery, but a profound insufficiency in the very principle of natural rights. Storing, in other words, takes this question and really raises it to the level of philosophy. If philosophy means forcing you to think back to first principles and to think back to the core foundation of all human consciousness and all human ideas, then Storing ultimately takes this specific issue of the practical dimensions of American slavery in the American regime and its consistency. And again, the way we normally experience this question is the consistency or inconsistency of the framers with their founding principles of rights. Storing, again, as you're going to see, turns this question in such a way that he takes the question to a new level of challenge and depth. So let's see how he does that. Again, on page 142. Having, I hope, rescued the founders from the common charge of that they shamefully excluded Negroes from the principles of the Declaration of Independence, that they regarded their enslavement as just, and that in their Constitution they protected property in man like any other property, I must at least touch on a deeper question, where they do not come off so well. But at this deeper level, the problem is not that they betrayed their principles. Listen very closely. The common charge, the problem lies rather in the principles themselves. Storing is trying to take you and now make you not only stand outside the horizon of American politics, but the whole horizon of modern political philosophy that generated the concept out of which modern politics flows. The problem lies rather in the principle themselves. That very principle of individual liberty, for which the founders worked so brilliantly and successfully, contains within itself an uncomfortably large opening toward slavery. The principle is the right of each individual to his life, his liberty, his pursuit of happiness, as he sees fit. It might be worth to go on with this quote on the top of page 143 to develop it a little bit more before we get to his more radical and most radical statement of this. He is, the individual asserting rights, that is, to be sure, subject to constraints in the pursuit of his own interest because of the fact of other human beings with similar rights. And that's the narrative in the Declaration, and indeed the narrative in Hobbes' Leviathan and Locke's Second Treatise and Rousseau's Discourse. And if you've had modern political philosophy, you know this narrative. We have to leave the state of nature with unrestricted rights to life, liberty, and property, and limit those rights in order to live with other human beings. But Storing suggests that those are prudential limitations that we lift so that we can continue our pursuit of our own interest. But are these moral constraints or merely prudential ones? And so you'll see he develops it over the next page. And here on page 144 is the full statement of this tension within the principle of natural rights. American Negro slavery, in this ironic and terrible sense, can be seen as a radicalization of the principle of individual liberty on which the American polity was founded. Jefferson wrote in his notes on the state of Virginia of the demoralization of the masters caused by slavery and its threat to the whole institutions of free government. Masters become tyrants and teach tyranny to their children and, incidentally, to their slaves. Even more important, slavery, through its visible injustice, tends to destroy the moral foundations of civil society. And quoting Jefferson, and can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of the people that these liberties are the gift of God, that they are not to be violated but with his wrath? Indeed, I tremble for my country when I reflect that God is just and that his justice cannot sleep forever, that an exchange of situation between whites and blacks is possible among events, and that it may become probably by supernatural interference. The Almighty has no attribute which can take side with us in such a contest. I do not think that Jefferson was literally concerned with divine vengeance. This was Storing now putting his interpretive gloss on Jefferson's quote. But he was concerned with the underlying tension, so ruthlessly exposed in the institution of Negro slavery between the doctrine of individual rights and the necessary moral ground of any government instituted to secure those rights. So what Storing has done is suggested in the very principle of rights itself. And I suggested this when we discussed the principles of the Declaration. And again, it takes it back to the Hobbesian foundations of these concepts. That what nature says is when you have a right to life and a right to liberty, that nature makes you needing certain things and makes it entitled to have them by virtue of placing with you the natural needs and the passions for those needs. You are naturally entitled to attain the things you need to remain alive. That's the Hobbesian, even Lockean, and Locke would extend it to property. The problem is are you obligated to respect the rights of other people? Now, you could say prudentially you are. That's what Storing admits. And even John Stuart Mill in the 19th century tried to form this, as Kant does in a way, into a universal principle of morality, that you can't do to other people what you would deny them the right to do to yourself. But if your fundamental right is to stay alive, and nature gives you the freedom, and Hobbes says this freedom is absolute, then not only can a starving mother eat her baby, she better eat her baby to stay alive. And that means if you consider that in your calculation, taking the freedom away from another human being and treating that human being as a property is the way that you conceive to secure your rights, then there may be this uncomfortable radicalization of self-interest in the principle that deprives your victim of the ability to protest the justice of what you're doing, the injustice of what you're doing. Now, by the way, as Story goes on to develop, this is the problem, because if that's where the slave owner then says, I have a right to your labor because I need it for my preservation and the wealth of my family, then ultimately it's hypocritical to insist that it's a crime for slaves to try to kill and rebel against their masters, because it turns out they're reclaiming in the state of war, and that's what Hobbes calls the state of nature, a state of war. But in the state of war, there is no morality. And so what Storing says is the problem of American slavery actually reveals a real profound limitation in the moral dimension of the principle of rights. And that ultimately asserting the right of the slave owner to take away the liberty of the slave and to treat the slave as a species of property ultimately destroyed the moral connectedness between human beings that all societies require. So what Storing is raising the question is, does the principle of natural rights form a sufficient principle for society to form the common good? This is an echo of the question that he suggests was raised in the tension between the Federalists and the Anti-Federalists, where the Federalists were both agreed on this view of natural rights in human beings, but that the Anti-Federalists sensed that the common good of society required a kind of a softening of that egoism, whereas in some ways the Federalists wanted an order which channeled that egoism, but did not ask people to rise above it, but simply to channel it. Storing's pushes this great question to the very foundations of American political life, in fact, the foundation of all modern political life, by raising the question of whether or not the principle of natural rights can indeed generate the form of consciousness of the common good and of the good of other human beings that all decent and moral society forms. Now, he pulls back from those terrifying depths of philosophic clarity. And but nevertheless, that question should ring in your ears as we contemplate the future of the American Republic, not even on the question of race, but on the question of, for instance, whether or not eventually modern human beings can develop the moral sense which society needs for its preservation and flourishing. That is a question that did not go away with slavery, that will not go away with any concatenation of modern politics. All right, so let's pull back from these terrifying depths and look at the conclusion of Storing's article, which in some ways, again, ends on a kind of a nuance, and as you'll see, tries to engage a hypothetical framer who responds to us looking back and criticizing his generation for the failure to solve the problem of slavery and indeed the problem of race. And that requires him to go back and look at Taney's opinion, which he, again, constitutionally and conceptually rejects and refutes. But if you turn to page 145, where he begins to frame the last part of his article and create a conversation between the hypothetical framer and our generation, and that is the question that Taney argues that the framers never thought that we, the people, could include African Americans. Not so much because of any genuine inferiority, but because rather of, and as de Tocqueville, as you will see, will pick up this theme when de Tocqueville meditates on the possibility of a future multiracial or biracial or non-racial society. And that is the prejudices of whites and the resentments of blacks as former slaves and the kind of resentment, the sense of inferiority. And by the way, much of that does resurface in our language of what's called white supremacy today, although you're going to see that that's one of the reasons why I think you need to look at this issue through the lens of de Tocqueville, who will render that issue much more complex and deep by making you look at aspects of it that we are not inclined to look at, as you will see when we come to democracy in America. So, on this question then, did the framers intend to exclude blacks from American citizenship? Now again, on the constitutional level, it's simply wrong. First of all, because he says that Negroes were not, just to remind you of the refutation of Taney's constitutional argument, that a black could never constitutionally be a citizen of the United States, because you had to be a citizen of a state, and that nowhere were blacks considered citizens. And Storing shows, as does Wilentz show, that was clearly false. It was just historically false, and that from the very beginning of the Revolution, that in northern states, emancipated blacks did become citizens, fought in the Revolutionary War as whites did, and in the northern states were actually citizens. And therefore that means that when the Constitution was formed, taking Taney's own principle that you had to be a citizen of a state in order to be a citizen of the United States, that shows that dimension, that conceptual plank of Taney's argument is in fact false. Now, but then look what he does on page 145. In this manner, Taney is simply wrong, but he had a better case at a deeper level. The way to this level is through the Privileges and Immunities Clause, which is Taney's real concern here, even though it was not involved in the legal dispute. And you look at this paragraph at the top of 145. He develops, which I was kind of suggesting in my comments on the Articles of Confederation, Article 4 of the Articles, which we, if you remember, we looked at last week, and is the Privileges and Immunities Clause. In the middle of that paragraph, Storing continues, the Privileges and Immunities Clause was the knife by which Northern freedom cut into the South, as the Fugitive Slave Clause was the knife by which Southern slavery cut into the North. And then he develops what, in other words, not so much that the framers constitutionally excluded blacks from American citizenship, but that they had doubts that whites and blacks could form a common civil society. Even after emancipation, even with emancipation. And this is why the framers like Jefferson, actually I won't go on to read this, but to explain what happens in the next couple of pages, is that's why they temporized with like resettlement of blacks in some other part of the country, like a black state, or recolonization back to Africa. Of course, and Frederick Douglass and most African Americans at the time rejected that because they insisted on the American part of their hyphenated identity. And that one way or the other, the experiment in American liberty that tolerated African American slavery would eventually have to look forward to a biracial polity where blacks and whites lived as equal citizens. Now, that's where Storing's re-engagement of it, because we have a tendency to criticize the founders and say, again, you should have made another decision. Slavery was so evil, like Garrison, that you should have rejected union. But again, the argument for accepting union and constitutionalism is had the union not come into being with the Constitution, the mechanism and the platform and the direction of setting the country in the motion of the abolition of slavery would never have occurred. The South could have formed its own country and slavery could have flourished. So in some ways, this goes back to Wilentz's claim and Storing's claim and Dedrick's claim and Lincoln's claim that the Constitution was an anti-slavery document which was intended by the framers to set in motion the abolition of slavery. But that doesn't solve the question of a biracial or a multiracial society living in harmony with each other. And you'll see that's where de Tocqueville picks up this question. So on this question of the framers' inability to solve the problem of slavery and eventually the integration of the races into a single society, on the bottom 147 through the end of the article, what might one of our thoughtful founders say in response to these charges? Here, let's read the paragraph before, because that's the American founders would have done their work better, it is now generally thought, if they had seen the need for and responded to the challenge of a multiracial, heterogeneous, open society. Instead, they toyed with unrealistic schemes of colonization, temporized with racism and racial segregation, delayed justice for blacks unconscionably long, and sanctioned second-class citizenship. They, quote, set the stage, in Hope Franklin's terms, for every succeeding generation of Americans to apologize, compromise, and temporize on those principles of liberty that were supposed to be the very foundation of our system of government and way of life, unquote. Storing. What might one of the thoughtful founders say in response to these charges and in the light of present-day circumstances in the United States? First, I think you would be amazed, Storing speculates, at the degree to which blacks and whites have progressed in making a civil society together. Although the bonds of that civil society, you have to say, were certainly strained in the last year. I think he would frankly admit that he would never have expected anything like the degree of harmony, mutual trust, and toleration and opportunity for blacks that have been achieved in the United States at the bicentennial of our beginning. Now, you might think, well, that's a very cheery take on things, and the death of George Floyd and the protests and the rioting and looting, which was his expression of bent-up frustration, you could say, that it's not exactly as if we've achieved that. But listen to what he says further on. At the same time, on closer inspection, he might wonder whether even the elementary question of whether the races can live together in peace has yet been settled. Beyond doubt, are the races so well bounded that long-term economic depression or large-scale war could not still tear them apart? It turns out that Storing is open to the question that perhaps that multiracial society of friendship that citizenship requires has not been attained yet. Moreover, in defense of his temporizing with racism and segregation and injustice, our founder might ask, what else could he have done? What, he might slyly ask our generation, what has been your most successful, perhaps your only successful, large-scale integration program? Surely the desegregation in the United States military forces, that example, now remember this essay was written in 1986, but he's probably right in some ways that the desegregation of the armed forces begun under Harry Truman prior to Brown v. Board of Education, prior to Rosa Parks, and prior to the civil rights movement of the 50s and 60s. Surely the desegregation in the United States military forces. That example is interesting in two respects. First, the success seems increasingly problematic, as festering racial antagonism and the worrisome prospect of an all-black army or infantry suggest. Second, to the extent that it is a success, why was that possible? Because, Storing suggests, an army is an army. But a political democracy is not an army. It rests on and is severely limited by opinion, which cannot be commanded. Prejudice, arbitrary liking and trust, and of course also disliking and mistrust, is inherent in political life, and its role is greater as the polity is more democratic. That irony that racism survives in the American regime because of its embrace of individual liberty and because of its embrace of democracy is a theme that, frankly, most Americans on either side of any political spectrum are hardly able to conceive today. And yet, as you're going to see, de Tocqueville will take us through a very profound reflection that what we call white supremacy may actually, oddly enough, be a byproduct of the democratic nature of the regime and its liberal character. Unless you completely, as Madison suggests in Federalist 10, give everyone the same opinion, interest, and passion, and or take away the natural liberty of human beings, which he says is the same thing, a liberal regime which rests on majority rule may have to struggle with these kinds of imperfections and tensions. Because it is a democratic and liberal regime, as we'll see. That's the great question that de Tocqueville raises. Finally, however, I think our founder might be intrigued on the bottom of 148, if not altogether persuaded by the prospect of a free society consisting not merely of a huge aggregation of individuals, but of diverse ethnic and religious and other groups. So, by the way, this is our ideal, to create a vast, multiracial, multi-ethnic, multi-religious society in which of such heterogeneity and what we today would call multiculturalism or cultural diversity or whatever you want to call it. And then to conclude the essay, reflecting on the bottom 149. Reflecting on thoughts like these and on present circumstances in the United States, our founder might concede that the huge problem of racial heterogeneity, which his generation saw but could not master, may show the way to deal with another problem which they did not see so clearly. And this is the radical insight that Storing makes you want to think about: the political and moral defects of mere individualism. He would surely point out that the foundation of this new polity is the old one, and he might wryly observe that his own principle of racial separation is, after all, an essential element in the new polity of racial and ethnic diversity. But I think he would concede, finally, that while in his heart of hearts he had thought that he and his generation had finished in its essentials the task of making the American polity or regime, there is, after all, work still to be done. And that is Storing's message to us in this generation. Let's grant that the American regime contains within it tensions and incompletions and even by the principles of the founding injustices. The task of a regime is to become what it is. The task of the regime is ultimately to have in the level of institutions, laws, and policies, and eventually citizen culture and way of life, what its principles proclaim. Now again, as Storing points out, those principles themselves may be profoundly problematic from the standpoint of producing the common good and civil society. That is an issue we shall be exploring the rest of this course.